Mr. Avenatti, who would have the authority to declare a state of emergency?
This proposed statute does not address that issue. That's already taken care of in the various other statutes that empower chief executives around the state to declare emergencies. So as I indicated, we may have a situation where the governor will declare a travel ban in certain parts of the state, and there may be a general election at that time. So the Board of Elections then can use the governor's declaration of emergency as the basis for implementing this new process. It is not mandatory that the Board of Elections do so, but it gives them the option, it gives them the authority to make a judgment on a bipartisan basis as to how to go forward.
Would it be fair that a local county executive or mayor of a jurisdiction be able to declare a state of emergency?
Yes, but the state of emergency declared by that chief executive is not binding on the Board of Elections. That's one of the many factors that they could include. And in fact, they don't need a state of emergency if some of the other factors are in place and someone else petitions them to implement the new process.
So, Mr. Avenatti, if there's a general election and there's various races going on from the statewide offices, the congressional offices, right down to the local town board, what if there is a state of emergency in the city or the village, for example? Will the voting only halt in that particular jurisdiction, or will it halt throughout all of the jurisdictions on that particular ballot?
That is a very significant question, and I appreciate your asking it, because I think that has to be clear in the legislative history what the intent is. This statute does not restrict the discretion of the Board of Elections on how to respond. So the Board of Elections could decide to go forward with the election in part of the district and delay the election for another part of the district. If you read the present statute allows just that. It allows for the Board of Elections to have an election in a district, but unfortunately it's only a primary and only after the fact. This will allow them to have a much more orderly process so they can do it in advance. They could decide, for example, to allow the election to go forward everywhere except in the one location which was affected by the flood, where people can't get out of their houses and can't vote, and they can schedule another election day either for that entire district or just the affected area. That would have to be done on a bipartisan basis. We've spoken to the Board of Elections on this, and they've indicated that obviously it takes bipartisan cooperation to schedule an election. It takes a certain number of days to do that, and both parties have to agree. Otherwise, they're not going to implement this new section of the statute. There also has to be time to notify the newspapers and give public notice as required by the statute.
In terms of the standard, Mr. Avenatti, right now it is less than 25% of the voters who could not vote in that particular election on that day if there's an issue. The bill that's being proposed will change that standard to an impossible standard. What are the purposes for the reason that you're changing the standard in the proposed bill?
Well, it's a determination by the Board of Elections that that the ability to vote has become or will imminently become impossible, and such impossibility cannot be mitigated during the scheduled course of voting. The present statute, which applies only to primaries, is an after-the-fact determination, and so there's a percentage put in there because you can make that determination. There's no way a Board of Elections in advance can determine how many people are in fact going to turn out. And there's no way to predict that, well, because a certain percentage lives over here versus a certain percentage living over there, and over here is having a flood, therefore we can predict the number. So I think this is the only way the statute can be set up, that there's an impossibility for the ability of voters to participate in the election.
Mr. Avenatti, in terms of the notice provision, which is on page 2, I noticed here that you have to also notify the town and city clerks and all of the municipal attorneys. I myself was a municipal attorney, one where I was the employee, others where I was an independent contractor, did not have an office at the particular town hall. Where would those notices be sent to the municipal attorneys And where would that information be found?
I would suggest that this would be governed by the other notice provisions of the general municipal law. I would assume, and I can't speak for the general municipal law, that if an attorney represents a municipality, they have to have a place for service in the municipality itself. I don't think we're expecting them to go chase down private attorneys wherever they happen to be located. Usually the place for service of any kind of a legal notice is at the municipality itself. But knowing in advance that there's going to be a problem, I think the Board of Elections and the municipalities can work this out themselves to make sure that everybody has notice. Because the purpose here is to make sure that as many people as possible get to vote, and so that they're not impeded by any weather conditions or other problems.
I have one more question, Mr. Avenatti. In terms of the standards for the impossibility for the general election, in the caucus provision, it is substantially impaired. Why is there a difference?
I'm sorry, which language are you pointing to?
In the general election provision, you have the word impossible in the bill, but in terms of the caucus, it is substantially impaired. There seems to be a different standard there between the two. I'm just wondering why that is.
Well, we're dealing with a different circumstance here. We're talking about a party caucus which is to nominate candidates, which can be dispersed and reconvened relatively easily. It's much more difficult when you're talking about canceling an election and moving it to a different day. And so I think this is a standard that was recommended to us by the Board of Elections. I personally see a basis for that, because having a party chair move a caucus from a Tuesday to a week or two later would require, in my mind, a lower standard than the ultimate of delaying an election.
Thank you very much.
I'm sorry, I may have misled you. It's 1 week later.
1 week later.
Right.
Thank you, Mr. Avenatti. I have no further questions.